Okay, everybody, I think we're just going to go ahead and get started. We still don't have more than half of the people who registered online yet, and that will happen sometimes with webinars. I would say instead of me muting you, why don't you go ahead and mute your own phone? Therefore, none of us could hear you, but you'll have the ability to unmute and jump in if you have any questions. As I said earlier, once we get to a point to where the number is pretty high, I'll just go ahead and take the initiative and unmute you. I'm just trying to keep it light and friendly so you can interrupt me if you have any questions. As I had said earlier, my name is Roxanne Wilson. I am, strangely enough, the data analyst for the Coalition of Homeless Services Providers. I say strangely because I haven't had to analyze data in quite some time. Here I am to present to you this kind of 2019 training series that the Coalition is offering our partners. As you may have saw in that email that I sent out yesterday, we had done a VAWA training to our board, and we just made it available to the public. If you want to, go ahead and check out our website. Again, it's www.chspmontereycounty.org. And in the upper right-hand corner, you'll see it says Continuum of Care Trainings and Webinars. And there you'll see everything that we recorded. I'll be placing it there for you to review or share with your partners. So today, we're going to be talking about anti-discrimination. Again, please let me know if you have any questions. Let's just go ahead and jump on in. So this training is going to focus mostly on the Fair Housing Act. I'm pretty sure most of you guys are familiar with the Fair Housing Act in some capacity, since everyone on the line is dealing with housing. But we're just going to go into a little bit more detail about the laws, and we're going to talk more about some best practices when it comes down to kind of the new hot topic, which is gender identity. So the Fair Housing Act, which is also known as 41 U.S.C. 3601, prohibits discrimination in housing-related transactions, including the sale, rental, and financing of dwellings. Discrimination includes refusing to rent to someone, steering someone away from a particular housing or neighborhood, enacting zoning measures to exclude particular groups, especially because of their membership of a protected class. The Fair Housing Act refers to this protected class, and those who are protected are groups that, the protected classes are race, color, religion, sex, familial status, which includes families with minor children, pregnant women, your national origin, and any type of disabilities. There are also new groups that are named as a protected class, which are LGBTQ people, persons with limited English proficiencies, and survivors of domestic violence. And again, if you want to learn more about the domestic violence protections, you should check out the VAWA training that was posted to our website. People with disabilities have the right to live in the community, to rent or buy housing on the same terms as others without any special conditions or agreements, to request reasonable accommodation for any disabilities that they may have, and they also have the same rights to housing units as any other tenant, assuming that they will be using a standard lease. Other relevant laws, you may have other relevant laws also include the ADA, which is the American Disabilities Act, which exclusively prohibits discrimination against people with disabilities. Section 504 of the Rehabilitation Act of 1973 protects qualified individuals from discrimination based on their disabilities. The non-discrimination requirements of the law apply to employers and organizations that receive financial assistance from any federal department or agency, which also includes HUD. And then finally, there's the Olmstead versus LC, which is a Supreme Court decision that reinforced the ADA and further mandated that people with disabilities live in the most integrated setting possible. So the FHA prohibits actions that have an unjustified discriminatory effect on people in a protected class. regardless of whether the action was motivated by discriminatory intent. I think that's important for us to know that it doesn't necessarily have to have motivation behind it for it to be tied to breaking the law, protected classes. Determining if an action has a disparate impact. Plaintiff must prove that the practice results in or would predictably result in a discriminatory effect on basis of protected characteristics. If proven, then the defendant must prove that the challenge practice is necessary to achieve one or more of its substantial, legitimate, non-discriminatory interests. If proven, then to prevail, the plaintiff must prove that the substantial, legitimate, non-discriminatory interest could be served by a practice that has a less discriminatory effect. Having a criminal record is not a protected class. However, if a housing provider has a criminal history-based restrictions on housing and without justification, their burden falls more on a protected class, the provider is violating FHA. So there's a test for discriminatory effect. Number one, does the criminal history policy have a disparate impact on a protected class? Does data show that people with disabilities are more impacted by the policy? If yes, is there a substantial, legitimate, non-discriminatory interest supporting the policy? If the policy excludes people because of past arrests without conviction, it does not pass this test. If the policy excludes all people with a conviction, no matter what, when or why, it does not pass the test. To pass, the policy needs to be more tailored to a certain types of convictions that causes risk to resident safety and or property. If yes, is there another practice with less discriminatory effect, better alternative, individualized assessment, taking into account all relevant information about the applicant? Also, intentional discrimination. If a housing provider intentionally discriminates by using criminal history information, that also violates FHA. An example is a housing provider rejects a housing application from someone with a disability who has a comparable criminal record to another applicant that was accepted. The exception. A housing provider can exclude a person convicted of illegal manufacture or distribution of a controlled substance, even if the policy has a discriminatory effect. However, if a housing provider excludes a person with a disability who has conviction related to distribution, but not other people with that conviction, that does violate FHA. Reasonable accommodation. A reasonable accommodation is any change in the landlord's policies that enables a person with disabilities to apply for, obtain, or live in housing. A person with a disability may not be denied a reasonable accommodation. Example, a building with a no pets policy must allow a visually impaired tenant to keep a guide dog. The FHA also provides for reasonable modifications, defined as a physical change made by the tenant at the tenant's expense that will allow a person with a disability to use the housing unit. Landlords must make reasonable accommodation in rules, policies, practices, or services if necessary for the disabled person to use the housing. Reasonable accommodation can help prospective tenants pass the application stage. Example, some prospective tenants with psychiatric or other disabilities have poor credit or no references or poor references from previous landlords. Reasonable accommodations for no credit or rental history might include use of utility or other bills to show that the prospective tenant pays on time, prove enrollment in training or service programs to show reliability, or have a relative or friend co-sign on the lease. Providers, including emergency shelter, transitional housing, and permanent housing, cannot deny admission to or separate any family members from other members of the family or caregivers based on any protected classes under the Fair Housing Act. Families includes, but is not limited to, regardless of marital status, actual or perceived sexual orientation or gender identity, any group of persons presenting for assistance together, with or without children, and irrespective of age, relationship, or whether or not a member of the household has a disability. What this means is that any group of people that present together for assistance and identify themselves as a family, regardless of age or relationship or other factors, are considered to be family and must be served together as such. Gender 101. Sex, the definition, is the classification of a person as male or female. At birth, infants are assigned a sex, usually based on the appearance of their external anatomy. This is what is written on the birth certificate. A person's sex, however, is actually a combination of bodily characteristics, including chromosomes, hormones, internal and external reproductive organs, and secondary sex characteristics. Gender identity, however, is a person's internal, deeply held sense of their gender. For transgender people, their own internal gender identity does not match the sex they were assigned at birth. Most people have a gender identity of a man or a woman, or a boy or a girl. For some people, their gender identity does not fit neatly into one of these two choices. Unlike gender expression, gender identity is not visible to others. Then there's gender expression, which is the external manifestation of gender expressed through a person's name, their pronoun, clothing, haircut, behavior, voice, and or other body characteristics. Society identifies these cues as masculine and feminine, although what is considered masculine or feminine changes over time and varies by culture. Typically, transgender people seek to align their gender expression with their gender identity rather than the sex they were assigned at birth. Finally, there's sexual orientation, which describes a person's enduring physical, romantic, and or emotional attraction to another person. Gender identity and sexual orientation are not the same. Transgender people may be straight, lesbian, gay, bisexual, or queer. For example, a person who transitions from male to female and is attracted solely to men would typically identify as a straight woman. And this is just a chart of how the different identities intersect over each other. We're going to review the 2016 Equal Access Final Rule. So the rule is, access to shelter, housing, and services is provided to an individual in accordance with the individual's gender identity. Again, that is what they identify themselves as being. It is required for all CPD programs. Individuals are placed in accordance with their gender identity. No requirements for individuals to prove their gender identity. So you cannot ask a person to say, okay, so you look like a female and you're saying you're a male, I need you to prove to me that you're a male. And also, providers must update policies and procedures to reflect requirements. Key elements of the rule. It clarifies that gender identity is wholly self-identified and separate from legal gender and or identity documents. It also prohibits intrusive questioning and requests for documentation, and it requires updates to all of our policies and procedures. So the continuum of care will be updating our policies and procedures, and we are asking that our providers do so as well to align ourselves and our entire continuum with the law. The Equal Access Rule applies to recipients and subrecipients of all CPD programs, which are Continuum of Care, Emergency Solutions Grant, HOPWA, Home, and I don't know if any of us are funded by Home. That's not the same as Coordinated Entry, by the way. CDBG grants, Rural Housing Stability Assistance Programs, and Housing Trust Funds. So why is equal access important? After 2012 Equal Access Rule, HUD found that transgender and gender nonconforming persons continued to experience significant barriers. 68% of the transgender people reported that none of their IDs had the gender or name they preferred. 70% of those who stayed in the shelter in 2015 reported some form of mistreatment due to being transgender. 26% of those who experienced homelessness in 2015 avoided staying in a shelter due to fear of mistreatment. The actual gender identity is I am a man. May be different than gender or sex listed on an individual's identity documents, and that those documents should not determine a person's gender identity. Perceived gender identity is you seem like a man. The gender with which a person is perceived to identify as opposed to the gender with which the person actually identifies. Your program policies and procedures should ensure equal access to programs for individuals and their families. It should provide housing, services, and/or accommodations in accordance with the client's gender identity. Determine eligibility without regard to actual or perceived sexual orientation, gender identity, or marital status. Program policies and procedures must not allow, what we cannot allow is for any of our caseworkers, social workers, intake workers to ask intrusive questions regarding an individual's gender identity, which also includes for documentary, physical, or medical evidence, anatomical information, or medical or physical history. HUD removed language from the 2012 rule that stated that under narrow circumstances, a written case-by-case determination could be made on whether an alternative accommodation for a transgender individual would be necessary to ensure health and safety. So that is no longer a part of the 2012 rule. The new rule states that all placements, including admission to facilities that required shared sleeping or bathing quarters, shall be made based on an individual's gender identity. After admissions, programs may take non-discriminatory steps that may be necessary and appropriate to address privacy concerns raised by residents or occupants. And for more information on the Equal Access Final Rule or the Equal Access for Transgender People Supporting Inclusive Housing and Shelters Rule, you can go ahead and check out these links. We're gonna post this information on our website, as I said earlier, so be on the lookout. We're gonna talk about changing the culture. Expectations should be clear and consistent at every level of the organization. You should have written policies and procedures. You should be having staff training, supervision, and management of staff, communication of expectations to clients, day-to-day interactions with clients, and implementation of written procedures in response to harassment or safety concerns. We also want to make sure that we're ensuring a safe environment. Train staff to use transgender inclusive language and use inclusive language in discussion and written materials. Consistently use correct pronouns and name. Understand and use respectful and accurate terminology. And then you're supposed to address conflicts quickly and in a way that protects client privacy, ensures clients are treated with respect, and is non-discriminatory. Do not disrupt a client's access to shelter, housing, or services because they experience harassment. Do respond to a client's privacy concerns. Also want to ensure that standards of behavior are clear to staff and residents and hold all persons accountable to those standards. Again, establish written policies and procedures for clients and staff. Go over written expectations with clients at intake. That is a matter of, again, creating the culture and the safe environment to protect all protected classes. And also you want to ensure that a client's sex assigned at birth is treated as confidential client information. Questions that we want to ask and not ask. What's appropriate is an open-ended question like, how do I identify your gender? Inappropriate would be asking the client for any form of documentation of their gender identity. Appropriate, informing the client that shelter assignments are determined based on the gender with which they identify. Inappropriate, There's questions regarding a client's anatomy, history, gender assigned at birth, clothing, or gender presentation. Appropriate is asking the client what feels most safe to them. And inappropriate is asking that a client defend or support their gender self-identification.